Hi, I am Rihanna here as an IT Ado. We are studying the subject Civil Engineering Project Management for 8th semester Civil Engineering. In this subject, we have completed all the 6 modules and now on the revision part. Today in this, I am going to give some discussions about module 3, that is related to construction disputes and construction costs. In the first part, we have to discuss about the construction disputes and settlements. What is construction disputes? Dispute implies assertion of a claim by one party and repudiation thereof by another. Repudiation means reject the proposal by another party. Usually, this dispute occurs because of the assertion of a claim by one party and the rejection by another party. A dispute arises when one party raises a claim and other party refuses the claim. So, construction disputes arise because of the disagreements between the parties on a contract. They are due to a perceived or real violation of a contract and obligations set forth therein. That means, construction disputes arises between parties because of the disagreements between them. Disputes may also arise due to the following reasons: lack of understanding of the conditions of the contract, delays on a contract, failure to administer the contract, and unsubstantiated or incomplete claims being made by the parties involved. So these are some situations due to which the disputes may arise. Next is the causes of disputes. Disputes may be caused due to errors in contract and tender documents. Sometimes there may be errors in case of contract documents and tender documents. This may create disputes. Because of the incorrect ground data or ground conditions, the availability of water, the depth of groundwater table, etc., certain ground conditions. Because of the incorrect data of these ground conditions, there may be a chance of disputes. Next is the use of faulty and ambiguous provisions of language in contracts. The other one is the deviations in contract documents or deviations in works. Because of unreasonable attitudes of the client and the contractor, there may be a chance of dispute. And the contractor being a poor standard, if the contract is being poor substandard, there may be a chance of dispute. Because of the unfair distribution of risk, the dispute may occur. Next, we have to know what is construction claim. A construction claim is either a claim against the contractor or the contractor's bond by the owner, or a claim against the owner by the contractor. So the claim may be raised by the contractor against the owner or the owner against the contractor. In both the cases, the claim is in important cases regarding money or time required to complete the project. Now we have to discuss certain types of claims. First one, demand for something considered one's due. The claim of contractor against owner or client. The claims of owner or client against contractor or subcontractor's claim. The second one is claims of contractor against owner or client. Claims to recover damages caused by breach of conditions by the owner. Second one, claims to recover the loss or damage caused by an unjust termination of contract by the owner. Third one is claims to recover damages upon rescinding of the contract due to frustration. So, because of any three reasons, the contractor can put claim against the owner or client. Next is the claims of owner or client against the contractor. Claims for defective work done by the contractor. Claims for delay caused by the contractor. Counterclaim as a defense. And claim against professionals. Because of any of these four reasons, the owner or client can raise a claim against the contractor. Sometimes the claims may follow termination and breach of the contract, and the claims for regarding the expenditure occurred in the work. So because of any of these claims, the owner or the client can raise a claim against the contractor. In this type of claim, the owner or client can raise a claim against because of these liquidated damages also. Next is the claim generating circumstances. There are generally certain circumstances which results in claim, which includes delay in supply of drawings and clarifications, defects in specifications furnished, delay or manufacturing defects in materials, equipment supplied by the owner, changes in law, regulations or codes subsequent to the award of the contract, changed or differing site conditions, delay due to other contractors' work, acceleration in work demanded by the owner, defects in the contract agreement, inordinate delay in the release of payments, unjustified termination of contractor by the owner, substantial delay in handing over the site, owner's failure in his implied duties, unreasonable rejection of acceptable work, delay in clearances, suspension of work by the owner for his own convenience, rescheduling or prolonging work for financial and other reasons, work arising during maintenance period which is not covered by the contractor's obligations, owner's delay in decision making or changing orders because of the variations in quantity, failure by subcontractor's quotation, stipulations of near impossibilities for compliance or incorporation into the contract work, natural calamities, and force majeure. So, because of any of these circumstances, a claim may arise. Next is the mechanism for dispute resolution. Generally, there are four mechanisms are adopted for resolving the disputes, which includes negotiation. By making direct negotiation between the client and contractor, we can settle the disputes. Second one is by mediation and conciliation. We can fix a mediator, which is a third party involvement, and through this mediation we can settle the disputes. And the third one is also like a mediation, which is known as arbitration. And the fourth one is settlement through court action. So I have discussed this in the class earlier. Because of the importance of this portion only, I have put the video, hoping that you have understood this. So today we have discussed about what is construction dispute, what is construction claim, which are the different types of claims raised by a contractor against an owner and an owner against a contractor, and which are the different mode of operations for settling these disputes. Hoping that you have understood this. Okay, study module 3 in an effective manner. Thank you. Stay safe. Have a nice day.